Contracts from Business Law for Everyday Use by Alonzo Rogers Weed. Contracts. What is a contract? An agreement duly entered into by competent parties for a legally sufficient consideration to do or not to do some specific thing is a contract. In order to constitute a binding contract, there must be, therefore, 1. An agreement, 2. Properly made, 3. By parties who are lawfully able to contract, and 4. Found on a consideration legally sufficient, 5. For some stated object. These 5 essentials are taken up in order below. Of the agreement. The agreement is the assent of the parties to the thing to be done. Ordinarily, there are but 2 parties to a contract, though either one or both parties may consist of several persons. Each party must clearly express his assent before he is legally bound. Thus, a proposal by one party must be accepted by the other within the time allowed in the proposal, or a reasonable time, if none is given, and the proposer must know of its acceptance. He can withdraw his offer too before it is accepted. The acceptance must be of the exact offer made, and if the offer is once rejected, it can only be accepted afterwards on a renewal of the offer by the proposer. If assent is given under an honest mistake as to the identity of the proposer, or the existence or identity of the thing contracted for, it will not bind the party so accepting. For example, if one bids on the wrong number at an auction, and on discovering his mistake immediately notifies the auctioneer, he need not take and pay for the article thus bidden of. But a mistake, however honest, as to the value or quality of the thing contracted for, or its adaptability to some purpose, or as to some general law of the land, will not avoid a contract. Every man is presumed to know the law of his own country and state, though not of other countries, or even of other states. Where assent is given under some illegal compulsion or restraint, or under threatened violence, the contract is not binding. Or if it is obtained by a fraudulent representation, it is not binding. To be fraudulent, however, the representation must be of a material fact, made with a knowledge of its falsity and an intention to deceive, and of such a nature as to deceive an ordinary man. A mere statement of opinion and generally of value, though falsely made, is not considered fraud in law. For example, if one told an expectant purchaser of a horse that it was worth $1,000, when he knew it was only worth $500, this would not be a fraudulent representation. A representation may be made by act as well as by words and silence, where there is a special obligation to speak out, will avoid a contract. As in effecting insurance, where a fact is concealed which would prevent insurance, or in a bank's securing sureties for a cashier, whom they know to be dishonest, or in selling goods with secret defects. In all cases, a fraudulent representation must have succeeded in defrauding in order to invalidate a contract. How contracts are made. A contract may be made in writing or orally, or even by a sign or nod. A written contract is preferable, for, in case a suit should be brought on it in court, its written terms cannot, as a rule, be altered by oral evidence. When a proposal is made by letter or telegram, the contract is generally considered closed when the letter of acceptance is mailed or the telegram of acceptance left at the proper office for transmission. The law is not yet definitely settled whether contracts by letter are closed on the mailing of the acceptance or on its receipt. All authorities agree that it is closed at any rate on the receipt of the acceptance. A proposer may avoid the difficulty by saying he will be bound on receipt of his offer. If a telegram received varies from the one sent, probably there is no contract. If this erroneous message is acted upon to the injury of either of the parties, the injured party has a claim on the telegraph company to the extent of his damage. But telegraph companies very generally stipulate, by a notice at the head of their message blanks, that they will not be responsible for variations unless the message is repeated from the office to which it is sent. If a proposal is revoked by letter or telegram, the revocation does not take effect till the letter or telegram is received. Public proposals such as offers of rewards, bounties, etc., create a binding contract with any one complying with the conditions of such proposals. Advertised timetables of railroads, steamboats, etc., constitute a contract between the ticket holder and the company to start their trains or boats at the advertised times and to make the trips on time, in case they announce the hours of arrival, unless prevented by some event or accident beyond their control. How made under the statute of frauds? By a statute called the Statute of Frauds, enacted in England in 1678 during the reign of Charles II, and substantially reenacted in all other states, the following contracts must be put in writing, signed by at least by the party to be charged thereon, i.e., a claim founded on one of these contracts cannot be enforced at any rate against the party whose name is not signed to a written contract statement on the contract. Of course, it is better that each party should sign the writing. 1. The contracts of an executor or administrator to pay the debts of the estate of which he is charged. 2. A promise to a creditor to pay a debt lawfully due him from another, or to be answerable in case of the default of this other. 3. An agreement made in consideration of marriage, as the agreement of a husband made before marriage to settle property on his wife. 4. A contract for the sale of lands or of interest in lands. This would include agreements not only for the absolute transfer of lands or houses, but also for making leases or mortgages of real estate, for conveying life interests in real estate, or rights of way over land or rights of flow land, and even in some instances, agreements for the sale of standing timber. 5. Contracts which by their terms cannot possibly be performed within a year from the time they are made. If the contract can possibly be performed within a year, even though the parties do not expect it will be, it need not be in writing. For example, A took a girl from the poorhouse, orally agreeing to support her till she was 18. The girl died within a year. A then sued the town for her support during her illness, claiming that his agreement to support her, being oral, was not binding, since it could not be performed within a year. But the court held that the girl's death had made it possible to fulfill his agreement within a year. 6. Contracts for the sale of goods, wares, or merchandise for the price of $50 or $30 or upwards. These 6 classes of contracts, if made orally, are not illegal or void, but voidable at the pleasure of either of the parties. Either party may refuse to be bound by such an agreement, but if the contract is once performed, neither can then retract on the ground that it was an oral agreement. Parties to a contract. In general, any person of legal age and sound mind is capable of making a binding contract, but certain classes of persons have an ability to contract more or less restricted. Aliens. An alien is a person born of foreign parents or foreign father in a foreign country. An alien has the same right to contracts as one of our own citizens, except while our nation is at war with his, and probably this limitation would not be enforced where the contracts had no connection with the war. Corporations. A corporation is an association of people, its stockholders, chartered by the legislature to act as a new and distinct legal person for the transaction of a specified business. A corporation can own property and make any contract relating directly or indirectly to the business for which its charter was granted. But any contract made outside its chartered powers cannot be enforced either by the corporation or by the other party to the contract. A stockholder may appeal to a court of equity to prevent a corporation from performing such a contract. For example, a railroad company could not be enforced to pay $5,000, which it had agreed to pay the managers of the Peace Jubilee in case of a deficit. Such a contract was considered outside the purpose for which the charter was given, although the holding of the Peace Jubilee in a certain town brought the railroad an increase of passengers. Drunkards. A contract made by a person so intoxicated as not to know what he was about is not binding upon him, unless he agreed to it after he became sober. It is binding, however, on the other party unless the intoxicated person retracts. Executors and Administrators. Where, in settling an estate, an executor or administrator makes new contracts or incurs new debts, he is personally responsible for them. But debts of the deceased are chargeable against the estate, unless the executor or administrator has agreed to become personally responsible for them. Guardians. A guardian is a person who is appointed by a court of law to have charge of the person or property of another, his ward, while the ward is legally incapable of looking after his own affairs. Guardians are usually appointed for minor children, generally orphans, insane persons, and sometimes spendthrifts. In order to take care of the children's property or to make contracts binding the children's property, a parent must be appointed guardian by a court, just as any other person would have to be. A guardian is not personally responsible for his ward's contracts, but only for contracts which he makes in behalf of the ward. Insane. A person permanently or temporarily insane is not bound by contracts made during his insanity, with the exception of contracts for the necessaries of life for himself and family. The insane person or his guardian must retract his contracts during his lifetime, or they will stand. Married woman. By the common law, a married woman's contracts made during coverture, i.e., while she is under influence and protection of her husband, are void. She is not bound even by the ratifications of her contracts after her husband's death or separation from him, if they were made during coverture. But now, very generally by statute, she has power to bind her own separate estate by her contracts. Minors. All persons under 21 years of age, both male and female, are minors or infants. In Vermont, Maryland, Ohio, Illinois, and a few other states, a girl is of age at 18. As a rule, a minor's contracts may be avoided by him at his option. But a boy of 14 and a girl of 12, in some states 18 and 16 respectively, can make a lawfully binding marriage, and a minor's contracts for necessities of life for himself and family are binding on him. Even in the case of necessaries of life, the minor cannot bind himself if he has a legal guardian and is properly under the guardian's control. And in any event, he is only bound to pay the reasonable price of such necessaries. As to what constitutes necessaries of life, a great deal will depend on the circumstances and position in life of the minor. Though a minor can avoid a contract made during minority, he will be bound by such a contract if he ratifies it when he comes of age. A mere acknowledgement of the contract, however, is not a sufficient ratification. He must clearly show an intention to consider the agreement a binding obligation upon him. In Maine, Kentucky, and a few other states, this must be put in writing. If he continues to take advantage of a contract made during his minority after he comes of age, it is generally considered a ratification. The right to avoid a contract on the grounds of infancy belongs to the minor alone, and the other party cannot make use of it. In case of minor does repudiate his contract, if it still consists only of mutual promises, the other party is released at the same time. If the minor has fulfilled the whole or a portion of the agreement and then repudiates, he can take back all he has advanced. If it is some form of personal property, he can recover it even from a third person who may have paid value for it. If both parties have done their part, then if the minor takes back what he has advanced, the other party may do the same. But he cannot force the minor to pay its equivalent in money in case the minor has parted with the identical thing advanced by the other party. Consideration. The consideration is the material cause which moves a contracting party to enter into an agreement. It is some loss or detriment to the party to whom the promise is made, such as the payment of money or the giving of some article of value or services rendered, or even his promise to do some of these things in the future. This consideration is really the inducement offered by one party by reason of which the other party enters into an agreement on his part. A simple promise made without consideration is not sufficient to create a legally binding contract, whatever may be its moral worth. One party to an agreement cannot enforce it at law unless he is engaged to undertake or is undertaking something in reliance on the other party's promise. Every contract must have a consideration to make it binding. But where a written contract is executed under seal, the formality of affixing a seal to the signature is held to be conclusive evidence that there was a sufficient consideration for the contract. A gratuitous promise, or one prompted by kindness or gratitude, will not support a contract. Though the considerations seem very inadequate compared with what is promised, the contract will be binding. The consideration may be expressly stated in the terms of the contract, or it may be implied, as in the case of a sealed instrument, or in the words value received of a promissory note or bill of exchange. The consideration for a promise must be something which the party promising could not legally claim before. For example, if A owed B money, and B agreed to give A book if he would pay him, B would not be bound to give the book to A on payment of the money. B's promise to give the book was without consideration, for A owed him the money at all events. The assignment of a claim or debt against another is sufficient consideration for the assignee's promise to pay the price asked for the claim or the debt. A promise to pay part of a disputed claim is binding, even though there was in reality no original indebtedness. So, a forbearance to sue a good debt will make a promise of the debtor to pay more than the debt, or of a third person to pay the debt, binding. Where services are rendered as an act of kindness, they cannot afterwards become the ground of a claim that they were given in consideration of an implied promise to pay for them. Mutual promises are good considerations for each other. An illegal, immoral, or impossible consideration will not support a contract. The object of a contract. Ordinarily, parties may agree to do or not to do whatever they please. Contracts in every form and for almost every conceivable purpose are being constantly made in business. There are, however, some limitations which public policy has introduced to keep these transactions within proper bounds. For this reason, a contract to do something which is absolutely impossible or which is rendered impossible by the laws of the country is void. But if its impossibility is simply due to circumstances such as the wrecking of a vessel, it will be binding. Contracts for the accomplishing of any of the following objects are illegal and therefore void, for the reason that since such contracts are forbidden by law, either party trying to enforce claim founded on them in court would have to allege at the outset that his right to recover depended on a lawful agreement. It should be said, however, that parties to such contracts do often consider themselves bound in honor to live up to their agreements, but neither of them should bring a suit at law on their contracts. 1. Buying or selling public offices or bribing voters or legislators or court officials. 2. Stock jobbing, i.e., fictitious dealing in stock where the broker pretending to buy and sell stocks is in reality buying and selling margins. 3. Agreements tending to shield public offenders, as for instance promising not to prosecute a burglar if he will return the stolen property. 4. Immoral contracts. 5. Contracts in general restraint of marriage. Such would be an agreement never to marry, but a promise not to marry a certain person would be binding. Contracts in general restraint of trade. This would apply to agreements never to carry on a certain legitimate trade again, or never to carry it on again within the limits of a certain state or of the United States. But it would not apply to a promise not to carry on a trade in a certain town or locality for a definite number of years. 7. Contracts between capitalists to monopolize the market or to make a corner in some commodity. This means that the capitalists acquire no rights between themselves on such contracts. 8. Contracts forbidden by statute laws. There are numerous instances of this class of contracts, differing, of course, according to the laws in different states, perhaps as common as any unlicensed or forbidden sales of liquor, contracts except of necessity and charity, entered into on Sunday, charging usurious rates of interest, etc. Kinds of contracts. Contracts are either 1. Specialties or deeds, formal written agreements signed, sealed, and delivered, usually in the presence of a witness. Deeds of lands and houses, mortgages, etc. are common examples of deeds. A good deal of solemnity attached to such instruments, and they are usually drawn after certain prescribed methods, blank forms of which can be obtained at any stationer's. As has been seen before, the consideration of a sealed contract cannot be called in question, even though it is not set forth in the instrument. Or 2. Simple contracts, verbal or written agreements. This class includes, of course, the bulk of business transactions. As appeared above, most contracts must be put in writing on account of the statute of frauds, unless both parties do as they agree to do on the spot, as is usually the case in retail trading. Where the terms of a contract are clearly stated, either in writing or orally, it is said to be an express contract. But if the law infers a contract from the acts of the parties, then it is implied, as where one avails himself of some benefit done him by another without his request. The law implies a promise on his part to pay, unless linked, indeed, the other rendered services out of the feelings of kindness. Where both parties have actually done all that they agreed to do, the contract is executed, but if it is an agreement to do something in the future, then the contract is executory. Where several persons acting together bind themselves to fulfill a promise, it is a joint contract, and they are jointly responsible for its performance. Where, however, several persons still acting together make a contract, but agree that each one shall be separately answerable for its fulfillment, it is a several contract. They may also bind themselves both jointly and severally, and then it will be a joint and several contract. Interpretations of contracts. The terms of a contract should be construed, so far as it is possible, so as to carry out the evident intention of the parties. For this purpose, words should be given their natural meanings, and reference may be had, under proper restrictions, to local business usages to explain obscure phrases or conditions of the agreement, but not to alter any of its terms. If a contract calls for the performance in any principal place or locality, the law and usage of that place or locality are to be followed in construing it. But if it is not to be performed in any particular place or locality, then the law and usage of the place where it is made will govern. Of their performance. Contracts should be performed within the time or at the time fixed by the agreement. If no time is fixed, then it should be performed within a reasonable time, a matter which depends almost entirely on the circumstances in each case. If a contract is to be performed by a certain day, which lapse happens to be Sunday, the time is extended until the next day, though negotiable papers bearing grace is an apparent exception. Courts of law cannot compel the performance of a contract, but they can give damages for breach of a contract. But courts of equity will enforce the specific performance of certain contracts where money damages are manifestly inadequate or impossible to ascertain. Thus, in a contract for the purchase of real estate, it is assumed that the peculiar advantages of location or neighborhood is the essential inducement, and that the particular lot or home contracted for cannot be duplicated. And the same is true in some instances with personal property where the article contracted for has a value peculiar to itself. But if the object of the contract is an article which can be readily and substantially duplicated in the market, equity will not interfere and the money damages can be had for a breach of contract. If any action on a contract, the party bringing suit or the plaintiff should have fully performed his part of the contract, or he must be ready and willing to do so, and only prepared by the neglect or refusal of the defendant to do his part. Otherwise, his action cannot be maintained. If the agreement is for personal services to such a nature that no one else can perform the services but he with whom the contract is made, as a contract with an author to write a book, or with an artist or painter a portrait, or a promise to marry, the death of that person discharges his debt, his estate, from any liability on the contract. Limitation of actions. As soon as a party to a contract is entitled to bring his action for the other party's breach, his cause of action is said to have accrued. But he must bring his action within the certain number of years thereafter, or else his claim under that contract becomes outlawed and worthless legally. This time of limitation is generally 6 years, but each state has its own rule in this respect, and the law of that state in which the suit is brought will govern any particular case. As a rule of part payment or a written promise to pay, if made within the time of limitation, will have the effect to postpone this limitation of the time to bring an action of 6 years, or whatever the period may be, from the date of such payment or promise. If the defendant is absent from the state at the time the cause of action arose, or during the time of limitation, such absence not being merely temporary, this period of absence is not generally to be reckoned as a part of the time limitations. An action to recover a judgment of a court of record may generally be brought within 20 years from the time such judgment is shared.